Ms. Gabriella, I spent some time watching the first meeting and then the second meeting and the discussion that members of the council have had with regard to the adoption of the new definition by the Planning and Zoning Commission. And as I noted in my first one, and I tried to bring it back here to the second one, is zoning regulations and the legislative authority for Planning and Zoning commissions to adopt those have a myriad set of impacts on various constitutional rights. The most fundamental one goes back to the right of property, and going back to Euclid, which is the original approval of zoning regulations in the United States, was the U.S. Supreme Court case back in the 1930s, where the question of whether or not that was an impingement on property rights guaranteed under the Constitution. So it's been a contest or a constant tension between the zoning authorities that are granted under state regulatory schemes and statutes and the constitutional protections for various activities within this. I think, and as I spent the last 2 weeks reliving my law school experience of reading more law review articles than I probably did in the 3 years that I was there, it became very clear that as you get further and further into this, the precedent is really all over the place. It's really fact-based, and those particulars, and even within this very, very similar set of facts, the decision law is all over the place. That's on that. So, you know, and the example I give is the idea of, I know people were talking, members of the council were talking a lot about rights of association. How do we balance those two pieces together on that? Associational rights are there really under the First Amendment of the federal Constitution, the right to assembly, to peaceably petition your government for redress. Those types of activities are always, to some degree, permitted to be regulated by zoning regulations. An example I gave in the opinion, whether, you know, being Irish, the Friendly Sons of St. Patrick's, the VFW post, if you have regular meetings that turns in my house into, you know, 50 cars lined up every Thursday night for a meeting, that's clearly, under any precedent, something that the zoning regulations can address on that. You don't have to own the building. If you're using the property for that purpose, it can be a zoning. So we do that. It's an associational right because people are associating together in that group, whether it's the VFW or whatever it is, the association they're under. Then you go down to the occasional, and I know there's a great deal of concern raised by members of the council. We get down to the level of a single event or small parties and things like that. How far can you draw the line? And unfortunately, the U.S. Supreme Court and the Connecticut Supreme Court haven't given us a lot of guidance as to where that line can draw. You look at the two cases I cite that are almost identical in terms of, just to back that up a little bit, most of the case law that has come out of this has to deal with the interplay of the First Amendment protections with regard to religion. And they're particularly focused, and where they seem to do the most litigation on is what the courts refer to as house churches, services in your home, on a regular or semi-regular basis, people coming over there to pray together, to worship together, to do some sort of religious ceremony on a regular basis. And as I point out in the two different cases, there was one case from Connecticut, the Murphy case, where the court found that it was an over-impingement under the First Amendment guarantees. There's almost an exact similar case down in Miami that they also had the Gross case down in the 11th Circuit. The Supreme Court hasn't resolved that tension yet. So as I've listened to and I've done my research, and I said, you know, UConn Law Review from 2010, the unsettling, well-settled law of freedom of association. It's been something that's been addressed in scholarship across the board. A lot of the original cases that are still good law, a lot of the legal scholarship has questioned the underpinnings of those. So when you look at questions of the Belterre case, which allows communities to limit the number of unrelated persons living together in the same household, which is still good law, and it hasn't been rejected by either the state court here in Connecticut or elsewhere. Is that really sustainable under the same-sex marriage cases that have come out, the equal protection developments that have come in there? There's a lot of questioning that in the legal law journals and the legal community on that. But until the Supreme Court acts on that, we're bound by the precedents that are on there. So, as I said, I've gone through it. I listened very carefully to the council's concerns and commission raised the issues, and they're legitimate issues as to whether the line is drawn in the right place or should it be adjusted on that. As I had mentioned at the end of my letter, in both the earlier letter and the second one, I think we've got a good feel for some of the concerns that the council has raised, and if we can work through with the planning and zoning and the particular impacts that members of the council have identified and that we can identify as we go through that, I think we can at least raise that with them in terms of making some adjustments to the regs as they've adopted them so far. So I'd be happy to try to address any questions. This is one you could have done your senior thesis on in law school and not quite finished it.
I'm going to recognize myself first as a council member, not as mayor. Murphy and related cases. It is my belief that the Religious Freedom Restoration Act, sometimes referred to as RFRA, has an impact on the religious cases. That's a federal law that requires any decision to limit free exercise, in particularly a zoning regulation that limits free exercise can be justified only by a strong showing, particularly strong showing by the municipality. Was that in play in Murphy? And does that possibly distinguish the religious cases from the question that you were asked?
Sure. RFRA is referenced both in the Murphy cases and the Grosh case out of the 11th Circuit. And in those, there's a number of cases that discuss that the protections of RFRA are coextensive with the First Amendment guarantees, because it was essentially, as the courts have stated, was an attempt to incorporate into statutory provisions the precedent, as they stood at that time, of the First Amendment litigation that they've done with regard to the First Amendment rights of religion. So.
One second. If you want to be recognized, just raise your hand. I'll recognize you.
Well, I just want to comment on that point.
You raise your hand and you're recognized. Well, I'm going to recognize everybody at one point or another, so go ahead.
Just on that point, the Murphy case is also a free exercise of religion cause case as well. But the point, the peaceable, there's a section, keynotes 3 to 5, peaceable assembly, that talks about associational rights that are not tied to religion. So some of the language that is most, I guess, instructive in Murphy is not tied, for our purposes, is not tied to religious use.
Okay.
Yes.
Yeah. So that distinguishes.
And if I could, in Murphy, the court took most of that on itself. It was not an issue that was briefed by the parties. The court delved into it on its own.
I will entertain additional comments or questions, Mr. Shaken.
Thank you, Mayor. And Kevin, I want to thank you for going back to law school on this. I know we asked for you to be to expound as much as you could on the subject, and it's helpful to see all of the sort of case law laid out and to understand where the rights to zone as a town to enact zoning regulations come into play. Sort of recognizing that this isn't a council issue to legislate, I just wanted to, I guess, clarify. So the first, I guess, part of what you wrote talks about the various different cases that have to do with what we might call regular use. So some, layman's terms, someone who has a weekly meeting of a church at their house, or a weekly, gathering that is basically meaning that their residential property is for at least at regular occurrence, at least being used for a different purpose. Is that correct?
Yes, and the regular, again, the differentiation for in a lot of the cases is how regular is too regular, and there's not a lot of guidance on that, frankly.
And Right, and then later you talk about more, I guess, occasional use, and that's where it gets murky and there's disagreeing opinions and it's not settled law or anything like that, right?
It has, and I think, although the council has talked a lot about associational rights, it's not the approach that's gotten folks into court. And that's why I tend to identify cases that are more religious-based because, again, it's the same First Amendment guarantees all those rights, but there hasn't been a lot of litigation on the associational right side of things.
Okay, and the ordinance that, or the zoning regulation that was passed by Planning and Zoning in June, is your read of it that it outlaws any gathering whatsoever of any frequency?
Yeah, and I'll tell you, and I mentioned that in the first one, I didn't spend the time to go through the various impacts of the change in definition as to how it's going to fit into the rest of the regulatory structure that they had. And that's sort of led me to the suggestion of let's get back and work through with staff and with the commission to see if there's areas that need to be addressed on that, so.
Okay. Well, again, since we can't change this, but I think it's a kind of thing where we could build a hill to die on this issue and potentially end up in court and be one of the communities that's helping to write the law on this, maybe even go all the way to the Supreme Court, but on something that maybe has a fix that we can make through language that gets more directly and exactly towards what I think the intent was that was shared by Ms. Painter and Ms. Mullen a few months ago to us of, look, we're only going to be enforcing this, that we'll use our discretion very clearly in this. I would hope that Planning and Zoning would reconsider this and be a little bit more clear in what exactly it is that they're trying to enforce. We have other mechanisms to get people in trouble if they have one nuisance party. We have a nuisance ordinance. We have all sorts of police enforcement activity. We have other zoning, parking regulations. We have a lot of tools in our enforcement toolbox without making any gathering at any home for basically any organizational purpose, not just college parties, but a meeting of the Democratic or Republican town committees in a residential neighborhood, political speech, anyone's Bible study group on a Sunday morning. I mean, the chess club that we all like to pretend exists when we're talking about this. I mean, any meeting. And so I really hope that they'll take another more close look at this and that they'll take this back up.
Mr. Freudman.
Yes, thank you. Yeah, I have the same concerns, and I want to dwell on those a little bit. I appreciated your letters, and you obviously put a lot of thought into it, but I think a few important points were overlooked. One goes to the very zoning regulations themselves, specifically the definition of a fraternal organization, which is paragraph 30, page 19 of the June 20th, 2017 zoning regulations. And I just want to read it. It says, it defines as a fraternal organization any, and I stress, any group organized for a common purpose, interest, or pleasure. I and a couple of other citizens in town specifically queried the director of planning and the zoning enforcement agent about that and gave some hypotheticals. You know, what if a few old ladies met at a friend's house every other Tuesday to play bridge? Would that, under the definition, be a fraternal organization meeting for a common interest or pleasure? And the answer was yes. Now, they all said, but we're not going to bother them. It's only if the police are involved, but that's beside the point. The point is that under our definition, that would be considered a fraternal organization. Now, whenever you are a fraternal organization by that definition, that makes the location where you're having that fraternal organization meet, makes you a fraternal organization house. And then where they get you is if you're not zoned as a fraternal organization house, you're in violation of the zoning regulations. And what upsets me about these is that they are selectively enforced. And that gets to my second point, is that in our packet, in fact, on page 139, you see a whole slew of nuisance citations issued, and every one of those, every address that they're issued to is to a student rental. Now, my point is that the zoning regulations, like the accompanying ordinances, were selectively chosen and selectively enforced to go after a particular minority in this town, which is, in this case, student renters. And where I think you kind of overlooked is you didn't just kind of parachute into the town and saying, oh, we have these rules. These regulations and the ordinances were put in for a specific purpose. They were put in because the town, people in town are angry that the University of Connecticut has enrollment now that's 10,000 people more than they can house on campus, and our neighborhoods are kaput, they're gone. They basically turned, in large part, one house after another by the hundreds, have turned into rentals. And people can't do anything about the state or the university, so they're going after the students and the landlords. And I think you've kind of overlooked or ignored the sociological context in which these regulations were put in, because I think if you had paid more attention to the context, maybe that would have informed your replies, because I think your replies are basically saying, well, yeah, you know, the courts give broad leeway, and sometimes they go this way, sometimes they go that way, but I think if you had looked more at the context in which these were put in, you would have seen they were done with a specific purpose, with a wink and a nod, that they were going to specifically be used against students, and as we can see from the nuisance ordinance citations, that's exactly how these zoning regulations and the accompanying ordinances are selectively applied. So there's definitely a discriminatory intent, which is impossible to prove in court. However, as an attorney, I'm sure you know that disparate impact can be used, and jurisdictions have wound up in court and had expensive consent decrees imposed on them, and they didn't have to prove that they were discriminatory in intent, just that there was a disparate impact on a particular minority. And in this case, that is clearly demonstrated by the way ordinances are enforced and through how zoning regulations are enforced through the ordinances. So those are the 2 points I wish you had looked at.
I will call on other council members. I would point out that the issue of what Mr. Dineen wrote was based on the questions that he was asked by the council members, by the council. And whether we like his response or not, it was responsive to the question. Now, Ms. Moran.
I want to follow up on what Mr. Shakin said. I think I belong to several organizations that would violate the rules. There's a sewing group that meets weekly in various houses. There's a book club that meets monthly in various houses. The town committee, Democratic Town Committee, has events in homes. And while I am fairly secure that neither my book club nor my sewing group would result in a call to the police for a neighborhood disturbance, and probably not my political party either, but sometimes it gets pretty rowdy, I really am a little concerned about the overreach in this. It's not that I question the idea that such a regulation is legitimate. I just think the language of this may sweep in groups that are not intended to be swept in. We are really looking for groups that have a history, a real history in this town of misbehavior, and they tend to be the ones that we have heard complaints about have tended to be, and I'm sure that it isn't exclusively student, but they have tended to be young adults who most of whom in this town are students, but they tend to be young adults who behave in a way that is very disruptive to neighborhoods. And I would like to see some attempt in the regulations to try to narrow this so it doesn't sweep in such a wide range of people.
I have 2 requests to speak, one from Mr. Katzenberger and another from Mr. Shakin. I have not seen any hands from any.
Question.
You have a question?
Quick question.
Then I think that Mr. Katzenberger wants me to take your question first. Go ahead.
Thank you, Mayor. I want to follow up on Councilor Freudman's statement and ask Kevin to respond briefly and to talk about disparate impact. And my very specific question is, does disparate impact affect all groups of people, or does it only affect what are considered protected classes?
I haven't done, obviously, the research sitting up here, but it's generally applied to protected classes. If the disparate impact that you see, and you don't have to have a disparate, discriminatory intent if you have a disparate impact, but that's been tied to protected classes of race, creed, color, national origin. I have not run across a class that found that students or there are some age protection classes, so you got to be a little bit careful in terms of how you, I don't want to give a drive-by opinion on what qualifies as a protected class under that. Age, under certain circumstances, Age Discrimination and Employment Act is for age 40 and above, so there are different areas on that, but it's generally toward either statutorily or constitutionally protected classes.
Hey, Mr. Katzenberger.
Thank you. And I also, like others have mentioned, Kevin, I appreciate all the work that went into this. If there was only an insurance law question, this would be my exam question for the class coming up, but alas, there's not. One thing, I also don't agree that this is, there's a discriminatory intent here. In fact, the definition of zoning or fraternal organization was broadened to specifically go beyond student organizations. I mean, and to reference fraternal organizations very broadly. I think that's part of the problem, but I don't think, I think it's also evidence that we're trying to move beyond, student parties, but to the nuisance themselves. And I think, from your earlier example, you mentioned, whether a religious group that has 50 cars, the issue, parking, the issue is really the 50 cars. I mean, the issue is the nuisance, if there is a nuisance, not whether it's the Mansfield Chess Club, one should exist at this point by now because we've mentioned it over and over, or Mansfield Neighborhood Preservation, or the Mansfield Democratic Society. But I wanted to ask, because the key point, I think, is on the top of page, 4, where I think correctly, the more nuanced question is presented in less regular gatherings or meetings. Even here, the interplay between First Amendment rights and zoning authority has led to contradictory decisions that have yet to be resolved by the U.S. Supreme Court. And I think, as a number of people have noted already, and now as well as previously, is here it's not regular use, it's any specific use. In fact, is there any case upholding, that you're aware of, upholding a zoning ordinance that would, prohibit even a single organizational event that does not cause an independent nuisance?
I've not found that address that issue, whether to uphold it or to overrule it. It just hasn't been litigated that I've been able to find yet.
Okay, so we don't have, so in this case, what we have is contradictory or inconsistent positions from the courts around the country as to, regular gatherings and less regular, but here we have, we don't even have the concept of regularity. We simply have that one issue. I guess I have a motion I'd like to put on the table when the mayor thinks appropriate.
Well, you can make a motion at any time. There's a myth that we only pass motions that are prepared by staff. Every council member can prepare a motion himself or herself. The preference under the rules is in writing, but if you don't have it in writing, you can read it and do it in a way that we could take it in and understand.
Well, I have it in writing, but I have it in writing on my computer. But
It doesn't help. It doesn't help me.
It's fairly short. All right, so this is the motion I would put on the table. I move we request the Planning and Zoning Commission to review the recently enacted regulation defining a fraternal organization in house, specifically the provision that prohibits individuals from holding any, quote, organization-sponsored entertainment or assemblage, end quote, in a private home in the restricted zones, regardless of frequency or size of such events.
That is your motion?
Yes, I have it in writing too.
And the town clerk will appreciate the opportunity to see it in writing. Is there a second to Mr. Katzenberger's motion? I
second it.
Oh, Ms. Berthelot, okay. The pending business is Mr. Katzenberger's motion.
I just had one comment.
You can speak in support of your motion, and then we'll throw it open to anybody else who wants to talk about your motion.
Thank you. Main reason, I think it's serious constitutional issues as it is addressed, in terms of, prohibiting any meeting, any single meeting. The second, and this I think gets to Mr. Freudman's point earlier, and others have mentioned, which is I think as a matter of public policy, we do not want to have a law that prohibits any organization from ever meeting, a fraternal organization organization, which is any, almost any nonprofit, from ever meeting, being able to meet legally in any private home in the state, in this town. I don't think that's good public policy, even if it was constitutional. So those are the two reasons, so we're trying to focus on the constitutionality.
Additional comments on Mr. Katzenberger's motion, Mr. Freudman?
I think the motion, as you worded it, may be a little flawed in the sense that you specifically mentioned that you asked Planning and Zoning Commission to look at the definition of a fraternal organization house. I think I heard you say that, fraternal organization house. I think just as important, I think even more important, that's paragraph 31, as you know, on page 19 of Article 4. Even more to the point is paragraph 30, the definition of a fraternal organization, because that's where it says that any group assembled for a common purpose, interest, or pleasure is how you define a fraternal organization. And it's from there that that house then becomes considered a fraternal organization house. So the paragraph 31 kind of derives from the problem that you would want to address in paragraph 31, actually derives from the definition of a fraternal organization, period, from paragraph 30. So I think it's a little bit too constrained. While we're talking about this, if I may, I want to say that...
As long as it's pertinent to the amendment.
Well, okay, no, I was going to continue with the other previous...
Now, this is, the pending business of the council is Mr. Katzenberger's amendment, and certainly the comments that you made were very relevant to the amendment. Ms. Moran?
Mr. Katzenberger, would you consider it a friendly amendment to request the review of fraternal organization and fraternal organization house?
Sure. I think the language, conduct of organization, sponsored entertainment, assemblage is in the fraternal organization house definition, but to review it as a group, sure.
Put me in a bit of a dilemma because I've spoken in the past of how I have a Robert's rules address this. There's a policy against having friendly amendments affect a matter that is a matter of substance, and the rule is this: once a motion has been stated by the chair, and I did, it is no longer the property of the mover but of the assembly. Any amendment, friendly or otherwise, must be adopted by the full body. There is a caveat, however, that an amendment might be non-controversial. It's proper for the chair to ask if there's any objection to adopting the amendment, and in the absence of objection, the chair may declare the amendment adopted. I'm reluctant to use that authority. So my preference and my ruling is that I'm going to require Ms. Moran to propose an amendment to Mr. Katzenberger's motion.
Mr. Mayor, we have a long-standing practice of technical changes, but for the purposes
This is not technical. Go ahead.
tonight's meeting, I would like to propose an amendment to Mr. Katzenberger's motion that would include a review of the definition of fraternal organization as well as the review of fraternal organization house.
That's that is the proposed amendment to Mr. Katzenberger's motion. Is there a second to Ms. Moran's amendment? Been moved and seconded. Is there discussion on Ms. Moran's amendment? Mr. Katzenberger.
Only that I support it, and I briefly added it into my draft amendment if you'd like me to read it.
I might after it's adopted, if it's adopted. Okay. Anything further on Ms. Moran's amendment? Okay. All in favor, raise your hand. Looks like it passed unanimously. So the motion now includes, as moved by Ms. Moran, to embrace not only fraternal organization house but also fraternal organization. Correct, Mr. Katzenberger? Have I stated it accurately?
Yes.
Okay. Is there any further discussion on Mr. Katzenberger's amendment? On Mr. Katzenberger's motion as amended? Mr. Shaken.
Thank you, Mayor. I support Mr. Kotchenberger's motion for reasons that I stated before. I just wanted to comment briefly on something he said about legislating. Even if this is an issue that we need to address, and I think that it is, the issue of there being sort of regular and disruptive parties in a number of our neighborhoods. I don't think that, I think that because we have, as a town, elected officials on the Planning and Zoning Commission, but elected officials nonetheless, who make decisions on what to do and what not to do, what to legislate, that we should decide to be a little bit more prescriptive in what we're going for. But I want to also make it clear that what we believe, or what I believe they were getting after here, which is ways to enforce our zoning regulations on properties that are creating significant nuisances to the neighborhoods that they are in, is something that we as a town still need to address, and that the Planning and Zoning Commission, I hope, will take into account. So my personal opinion is I think they may have overstepped a little and gone a little too far, but at the same time, I don't think that this is a way of the council expressing our desire for there to be parties in every neighborhood. I think, in fact, quite the opposite. So, so I hope when they take a look at this, if they accept our suggestion, if the motion passes tonight, that they will look to it with an eye to more clearly define exactly the use of land that they are trying to regulate, and not to blanketly prohibit all gatherings for sort of any and all purpose. Thank you.
Additional comments on Mr. Kotchenberger's motion as amended, Mr. Friedman.
No, if you want planning and zoning to look at this, I think it's worth keeping in mind that what's happening here is we're looking to planning and zoning to regulate what amounts to behavior. And I heard somebody from staff once say, I don't remember who it was, that zoning regulations work best when they're confined to use of property, not to behavior. And you're looking here more to control behavior, I think, than use. Because let me say something about disruptive parties. I live, as you know, behind the high school, very close to campus. And I know there have been times over the years, not so much now because a lot of the faculty members have died or moved, but there used to be a lot of active faculty members on my street. And there would sometimes be faculty parties, and there, as you know, my street has basically no shoulders, and people would be parked up and down on both sides of the street. We're not talking about parties like the students have where they're parked off-street, they're not blocking the street, and they're still getting tickets, still getting nuisance ordinances. You talk about disruption, but nobody would bother them, and the problem, because it was faculty. Now, I have to say, sure, I will support this motion, and I hope Planning and Zoning pull something out of their sleeve that's wise. That would be good, a good thing. But keep in mind, every one of these regulations and the accompanying ordinances were all envisioned and enacted with a wink and a nod. They know who it's targeted at, and they know how it will be enforced and who it will not be enforced on. And that's something that transcends everything they do, and everything unfortunately, much of what the majority on this council does is it's very selective, and it's understood that it will be enforced selectively. And if anyone has any doubts about that, just look at page 139 and see which properties get the nuisance ordinances or the parking, off-street parking citation ordinances. It's always student rentals. And that's the problem with these regulations, is it's all done with a target in mind. I don't know how you get around that problem.
Ms. Moran.
Frankly, Mr. Freudman, if there were rowdy faculty members, I would strongly support enforcement against their parties. Unfortunately, the faculty members I've known in recent years have been very quiet and dull. No rowdy parties, but that was just a side comment. Mr. Mayor, I assume that if this passes, that you will put this motion into a letter that is addressed from the council to the Planning and Zoning.
That's our custom. Mr. Friedman, addressing the Kotchenberger motion.
Well,
as
I'm
amended.
actually replying to something Councilor Moran said, directed to me, which was that it was about rowdy this or rowdy faculty, the faculty not being rowdy. I can say that, again, if you look on the nuisance ordinance citations that are noted on page 139, there were several issued to my neighbors on 1 Eastwood Road. And I really resent it, because these are peaceable neighbors. They were having a party. The few cars that were there were, off-street, on their long driveway, and they weren't bothering me and not bothering anybody that I know of. It was just, as I said, these are selectively enforced. They're done with a wink and a nod. They were not rowdy, I say. My neighbors were not rowdy.
Anything in addition on this amendment, on this motion as amended? All in favor, raise your hand. Passed unanimously. Thank you. Thank you for your scholarly research, Mr. Dineen.